Today we are only going to be talking about family law. We are not going to be able to answer your questions pertaining to immigration or immigration law. Joe, good evening. How are you doing this evening?
I'm doing well. How about you?
Very good. Thank you so much. So like how we've done these previous segments, Joe, is there something specific you want to talk about in family law today?
Well, there's a number of things we can talk about. I've got a number of notes that I can refer to.
Sure.
But I thought I might begin by talking about two things: informal marriage and people that have issues from outside the country. And I'll round that out and make that more specific. But I first wanted to tell people sometimes people come into the office and they have not been formally married. Now, Texas honors out-of-country marriages. Even if people would not be able to marry in Texas, Texas will honor a marriage from outside. For example, in Texas, you can't marry your cousin, but in some countries, you can marry your cousin. And Texas will honor those marriages, but if cousins want to get married here, they don't allow it. Or I guess it'd be more accurate to say they won't grant a marriage certificate. Now, a lot of our clients come from Asia, a lot of the Mediterranean area and all over that region. I wanted to talk to people about something that comes up periodically. I probably deal with this every week, and that is, can we just go back to Pakistan or India or Nepal or wherever we're from and get a divorce there? Will Texas honor that? The answer is basically no. If Texas has jurisdiction, which means you've lived in Texas for 6 months, and if the county has venue, which means you've been in the county for 3 months, then Texas and that county have jurisdiction. And they won't honor an out-of-the-country divorce because they have jurisdiction here, and you have to get the divorce here. Now, I have yet to find a way around that, but I just wanted to make people aware of it. So that's a little bit about marriages outside the country and informal marriages. Now, informal marriages in Texas, two people who present themselves as husband and wife to other people and intend to be married are already married in Texas. If you cohabit, and there's no specific time limit, the Texas statute doesn't even say you have to be together one day. But if you decide to be married and you intend to be married and you present yourselves to other people as husband and wife, a good example of that is you file joint taxes. Then in Texas, you are married. Now, Texas has informal marriage, but they really don't have informal divorce. So if you're informally married in Texas, you may have to go through the divorce process. At least if you have to have problems that need to be worked out, you would need to go through the divorce process. Now, I believe the statute on informal marriage says that if it hasn't been raised within 2 years of separation, the marriage may fail by operation of law. By the way, if anybody has any questions, feel free to call in. I'll be glad to answer any family law questions you might have.
She got divorced in 2014. As per the agreement, her husband was in possession of her jewelry, her mom's jewelry, and he was supposed to pass it on to the kids once, at the time of their marriage. Now she is extremely upset with the fact that her ex-husband has gone ahead and sold that jewelry, and now there's no way for her to get that jewelry back, and for her to make sure that her kids actually get the jewelry, and she's extremely upset with this. What recourse does she have? Who can she go to? How can she take this up, legally?
Well, if there's a divorce decree that clearly states an enforceable order in regard to the jewelry, and I'd have to review the decree to tell you for sure, but if the order is enforceable, she might be able to either get a money judgment or a force of return of the jewelry, if that's possible, or whatever, by going to the original court that granted the decree and filing a motion to enforce that order. So if there's an enforceable order regarding the jewelry, she might be able to do a post-divorce action for enforcement of that part of the decree. Now, unfortunately, it might get kind of expensive. So the first question I would ask is what the jewelry was worth. And if it's worth $10,000, it might not be worth spending $5,000 or $7,000 and then maybe or maybe not getting a recovery. It's a tough issue, and I'm sympathetic to the situation. But sometimes people are not honorable and they don't keep their agreements. But it really depends a lot on the wording of an actual court order. If there is no court order, there's not much you can do there. I mean, you could claim theft, but if the property was in his possession, I don't know that theft really works in that scenario.
Right. Joe, thank you so much for that. And ma'am, if you're tuned in, if you just heard Attorney Joe Powell, I want to let you know that for you to discuss further details regarding your case and for Joe to have those data points to be able to give you more critical advice, the number to call is 214-881-2100. That is the number to Attorney Adam Malik's office. That is 214-881-2100.
I thought I might give people kind of a skeleton view of what is involved minimally in every divorce process. The thing that actually will start a divorce process is the filing of a petition for divorce. Now, all a petition is in Texas, it's a request of the court for the court to grant whatever relief you're asking for. Petitions are filed in Texas for any lawsuit. That's what begins the case in Texas. We have a caller?
Joe, we do have a caller. I'm going to take them on air with your permission. Good evening. You're live on air. Please go ahead and ask your question.
Yeah, hello, this is Juan. If the couple is divorced like some years ago and the property is in another state and like the wife is in this state but she's divorced and the property is in another state, so what can we do?
Well, it kind of depends on the wording of an order. Is there a court order in Texas?
I'm sorry, Joe. I think we've lost them.
Oh. Well, I don't know how to answer that without asking some questions. Let me see if I can give some general idea there.
Sure.
If there's out-of-state property, but it's a Texas divorce, Texas can generally divide all of the property of the parties if it was acquired during the marriage. Now, in some cases, Texas can and should apply the law of another state or another jurisdiction. This sometimes comes up with people out of the country. Now, Texas can't really apply like India law or Missouri law or New York law, and Texas attorneys aren't familiar with the law of the differing states. But you may be able to file for enforcement in Texas if there is a Texas order that's properly drafted and if it has that property named in the divorce decree, assuming there is one.
Thank you, Joe. With that, we are going to take our next caller on air. You're live on air. Please go ahead and ask your question.
Hey, Joe, this is Victor. Me and my wife bought a house in Texas about 2 years ago, but recently we have been working on a divorce back in India. The question that I have is, when we are currently working on the divorce back in India, what happens to the property that we both have bought here, where she has also has signature on as part of the homestead agreement? How do I navigate through the process? Can you please guide?
Texas dealing with property out of the country can be tricky. Now, if the property is in Texas, and if you all reside in Texas, I don't know that you can file for divorce in India and have it be valid here. Most of the time, if Texas has jurisdiction, the other country does not have jurisdiction. Now, I don't know your exact circumstance. I'm trying to be general with my response. So there may be some tricky issues with your situation. I'd really recommend that you consult with an experienced family law attorney. In our firm, there's a small fee just so people show up. But it's not very expensive to have a consultation, and I think in your situation, consulting with an attorney might be a good idea.
We're going to take our next caller on air. Fanasia, you are live on air. Please go ahead and ask your question. The lady who called is now on air. The question pertaining to jewelry, right?
Oh, yeah.
So she just wants to elaborate on that, and she has a couple
Okay.
of follow-up questions. Please go ahead,
Okay.
ma'am. Yeah.
Sir, my ex told me that he's getting married and he's looking to call his fiancée to America. And I know he lied so many times to me, and now he say he have no money. I'm thinking about his lying to them, to my case that he sold the jewelry. I don't think so he sold the jewelry because he want to give to his wife some kind of jewelry, because that jewelry is very, 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 very expensive. Very expensive, not a $10,000. Yes,
Is there
sir.
an order in Texas in regard to the jewelry?
Yes.
Okay. I would need to look and see if that order is enforceable. It might
Sure.
be.
I love you.
But if he doesn't have any money and if he's already sold the jewelry, you're not going to be able to collect anything.
He said that because I don't believe it.
Well, I'm just saying, I doubt that he broke the law. He may be a liar and he may be a thief. That's entirely possible, but I'm not positive that anything can be done. I recommend that you consult with our office.
Joe, welcome back. And I know that, you were answering that question that was posed
Right.
by the lady where her ex-husband now refuses to give that jewelry to their kids. And this is what is causing her a lot of angst. So once again, Joe, if you could just simplify it for her, because I know that, she is tuned in now. And if you
Okay.
could just let her know what is the recourse she has, what can she do? What are her potential alternatives here?
All right. If there's an enforceable order, that's the first assumption. If there's an enforceable order, it's possible to do a post-judgment action in the court and ask the court to enforce the part of the order that has to do with the jewelry. The problem is, if the jewelry's been sold or if it's impossible to locate it, it's been hidden or whatever, it may cost a considerable amount of money to try to locate it.
Right.
And sometimes people can get a judgment, but it's not collectible.
Mm-hmm.
If the other person doesn't have any money or doesn't have the jewelry or doesn't have anything you can really get at, you may get a judgment that's just a piece of paper. And I was using you as an example. If I had a $10 million judgment against Piyush, unless he's got a family trust fund out there somewhere, a lot of money, I just have a piece of paper, and if it's completely uncollectible, I can't put him in jail over a debt. There's no debtor's prison in the United States. You might be able to force somebody into bankruptcy. You might be able to affect their credit in some circumstances. You might be able to get a judgment. But collecting on a judgment, everyone should consider, if I get a court order that orders the opposing party to pay me a sum of money, can I collect it?
Right.
And attorneys should be honest with you about that. All competent attorneys should tell people the truth, not necessarily what they want to hear. Everybody wants to hear, yes, I can take care of your case, there's no problem, whatever. But sometimes these cases are very, very difficult, and they can get very expensive. Even a moderate hourly rate, like our firm keeps their hourly rates moderate, but even moderate hourly rates add up quickly if you have to do 10 or 20 hours worth of work. And that's another thing that people need to be aware of. If you think about it, if you come into a divorce lawyer and you want a divorce lawyer to help you, it's quite possible that you may want that attorney to do 10 hours worth of work the first month and 5 hours worth of work several subsequent months to get something done on the case. Well, you just add it up. Every attorney's charging several $100s an hour,
Right.
including our firm. We keep our costs moderate, but that can add up a lot. 20 hours at $350 an hour, for example, that's $7,000. So I try to tell people honest appraisals of what the costs can be. And most family law attorneys can't do anything on a flat rate. It's just family law can be very, very time intensive, and the attorney has to be able to make some money on a case.
Makes sense. No, absolutely, Joe. Thank you so much. And I want to just summarize this, like, in layman's terms here, Joe. So what you're saying is 2 or 3 important considerations. First, the lady here needs to evaluate what that jewelry is worth, right? Whether it even makes sense to go after, file a lawsuit, whether it's even worth the effort, right? The second thing that you've got to evaluate is that even if you get a court order which is in your favor, whether that money is collectible. I mean, if the gentleman there, 1%, if you were to believe what he's saying, and if he doesn't have any money, then what is the probability of you collecting the funds, right?
Almost zero.
Almost zero.
And another thing, I believe that lady was saying that the divorce happened several years ago. Therefore, the order in regard to the jewelry has to be clear and enforceable. So she might need to have an attorney review that and see if the actual language in the divorce decree, if something can be done with it. Then the issue is back to, does the person have the resources to make the judgment collectible if we get a judgment? A judgment is just a piece of paper. Now, the court can enforce things, but people don't go to jail on debt in this country.
Right.
There's no debtor's prison in the U.S.
And Joe, I really appreciate that advice. Like you said, the impacted party, maybe it's not music to their ears. Maybe that is not something that they're looking to, that they want to hear.
Right.
But I really appreciate you being forthright and candid about this. And with that, I think you can continue the conversation, Joe. If there is, a caller, then I'm going to have to interject and take them on air.
Of course. Well, I was kind of giving people earlier a little skeleton view of the divorce process, and I started with the filing of a petition. The second thing that happens, once that petition is file stamped by the court and accepted by the court, you can have a citation issued, and you can have a constable or a process server actually serve the person with the papers. That brings them into the lawsuit if they're personally served. And personal service is always best if it can be done. I recently served a person in Canada. We got that done with very little trouble. I recently served a person in California. We found them, and then we got them served in California. So those things can be done, but I try to avoid things like service by publication unless it's necessary. If you don't know where your opponent is, then you can do service by publication. And what that is, it's an ad in a commercial newspaper that tells a person that they've been served if they happen to read that commercial record newspaper. And not very many people read those things. So service by publication is possible in some cases. It's necessary in some cases. And the court will honor those and grant a default decree. There's some problems there because if a person is served by publication, they have 2 years to fight an order that's been entered. So there's a few problems with it, but it can be done. If you literally do not know where a person is, they've gone back home to another country, but you don't know what city they're in or anything, they can't be found, they can't be located, you can do service by publication. Now, once a person has been served, they have a responsibility to file a document with the court, either an answer or a counter petition, or file a waiver. Generally, we can offer people a waiver where they don't have to be served. And then once a person is served, they have about 25 days. They've got 20 days, and then the following Monday at 10 o'clock to file a response to the petition. So the petition starts the lawsuit. The answer or counter petition tells the court what the other side, what the issues are for the person on the other side. Now, a little bit about once there's been a petition and an answer, a person's been properly served. Sometimes there's a temporary orders hearing. A person can file a motion for temporary orders. A person can just set it for a final trial, but that's usually around 6 months or more out because these courts get busy and they have to schedule things. So a final trial setting might be months down the road. Now, in family law, there's generally only two major points of disagreement, and that is children or property. Almost everything in family law that's a dispute is going to be either over what do we do about the children or what do we do about the property. If people have extensive property, it may be expensive to get all the information gathered that is needed to make good decisions about extensive property. The simplest divorces are no kids, no property, and most of the time those can be done quickly, and generally they don't get horribly expensive. But if there's intense disputes over children or intense disputes over property, chances are it's going to take some resources to find out and resolve those issues. Sometimes one person will have control over all of the information, and the other person has almost no information about it. The person in control of the property is rather secretive, and they don't tell their spouse what's going on. 10 years down the road, there's been an accumulation of $1 million worth of property, but one of them knows about what the property issues are, and the other one doesn't know. Maybe they have some clues. They've purchased an $800,000 home. The home can be resolved, but what if there's extensive investments or other property that's owned in businesses or investments? Now, in Texas, all property that's acquired by your time, talent, and labor, by your work, that's community property. The person that's earning it has control of it, but they don't own it, not outright. Community property in Texas, unless you have a prenuptial or postnuptial agreement that makes everything separate property, which is what a prenuptial agreement normally does, unless you have that, community property is going to make most property divisible in a divorce action. So property issues can cause some substantial conflict, and those conflicts have to be resolved in some manner. I advise people on both sides of a divorce, if you cooperate with each other and provide each other with the information that is needed without a big hassle, without having to go through a formal discovery process, informal discovery tends to be much less expensive. So I advise that when it's possible. Now, discovery is questions or document production requests that give you the information that you need about whatever the issues are. It may be issues about children. It may be issues about property. But discovery can get at some of the facts of a case that the other side needs in order to proceed. If everybody knows about the property, usually those things can be resolved pretty quickly and informally, and that's much less expensive. Formal discovery is expensive. Informal discovery, the client just has to come up with the information, and we can pass that information on to the other attorney. Informally, that's easy. Formally, the documentation that's necessary is time-consuming. It's very, very easy to have to spend 10 hours or 20 hours of work just to do minimal discovery. In Texas, both parties are supposed to do disclosures unless they're waived. Disclosures are a form of discovery, and it's kind of a cross between document production and questions or interrogatories. But in disclosure, nobody can object to those things. They have to be provided. Now, there are issues that don't apply to a given family situation, and in those cases, you can just say, it does not apply. A lot of times people come into the office and legitimately they would like to keep the cost down on a case. And here's what we generally recommend in those kind of cases. Mediation does involve some expense, but it's not as expensive as getting ready for a full-blown court trial at the end of a divorce action. mediation resolves about 80% of the cases that are taken to mediation. And so we recommend to people that they consider trying to reach agreements if they have sufficient information. And that's one way of cutting down the overall expense of a divorce action. And by the way, sometimes people have children and they're not married.
Joe, I'm so sorry to interject here. We have a caller and we've got a minute left. So we've got 60 seconds left. Please keep it very short and simple and ask your question. And Joe, what I'm going to do is you can discuss the answer, off air with me, and I'm going to say it aloud when we are back. All right, please go ahead and ask your question.
Yeah, my wife has been threatening me with some, whenever she gets angry, like she says she's going to call cops, or she's getting aggressive, and recently she started stepping out of the home and coming, a day or 2 days after. I mean, she's going to a friend's house and staying, that part I know, but to protect myself, is there anything I can do other than initiating a divorce process? Because I need to see anything changed medically in her before, go. But I just want to protect myself and my kids from this.
I don't need the details, but you're being accused of abuse. Those are tricky cases. You can record. You don't have to tell her that you're recording. I recommend that you don't. And you can save your text messages. You can take pictures, whatever. But abuse allegations are going to be dealt with the court, and they can be very damaging. If her testimony seems credible, a judge may grant her some relief. So be very, very careful, and you have a right to call the police if nothing's going on, but she's making threats. You can ask an officer to come out on a domestic standby and create a record of what's going on. But document everything you can, write down incidents that happen, and put them down and make a record of it so that you can go into court and say, here's my notes from that day. I wrote down what happened. And that can be helpful. That can be helpful. But the only thing I can tell you is if there's abuse allegations, document everything you possibly can.
Okay.
All right, Joe, thank you so much for taking that question. And sir, thank you so much for calling. Joe, once again, thank you so much for joining us.
Thank you. Take care.
You too. Bye. Yeah.